Okay, I think we can get started now. We have Assemblyman Perry, Assemblyman Lenthal, and I'm John DeFrancisco from the Senate. The purpose of this hearing is to discuss issues surrounding the prosecutorial conduct bill that both Mr. Perry and myself have in the respective houses. And what we try to do is get a balance of people that may have different viewpoints on this to give their opinion, and then thereafter we will be able to have some interaction, some questions and answers, and the like. There's 12 people that have been asked to testify, actually more, some canceled, and some were added. The reason for the setup as it is right now, I thought, and we all thought, that it'd be good to have a balance of opinions on the first round, rather than having one side or the other on this issue, monopolizing it until people get tired. So that's where we were. So if the first group, if we go left or right, just identify yourselves, and then we can start the hearing.
Good morning. Albany County District Attorney David Soares.
Good morning. Oneida County District Attorney Scott McNamara.
Bennett Gershman, Professor of Law, Pace University.
Marvin E. Schechter, Criminal Defense Attorney representing the New York State Association of Criminal Defense Lawyers.
Robert Temekjian, the Administrator and Counsel to the New York State Commission on Judicial Conduct.
David McCallum, exoneree.
Keon Daniel Katibi, exoneree.
All right, now, what I'd like to just mention, if we could try to limit our initial remarks, hopefully to 6 or 7 minutes, just to give your general impression, and we could start the discussion thereafter, and then we'll rotate so that everybody that was asked to be here can put their 2 cents in and be subject to questions. That's basically what's going to happen. It's being live streamed, I guess. So you're all dressed nicely and you look good, so that'll work. So there may be a movie career in the future for all of you. But in any event, if either Assemblyman Lenthal or Assemblyman Perry would like to make some opening remarks, we'll go from there.
Well, I don't want to preempt the sponsors of the bill. I guess I'm here to be a moderator between the Assemblyman and the Senator, as well as you. I'm the chairman of the Assembly Codes Committee. So I'll ask Assemblyman Perry, since it's his bill, to make some opening remarks if he wants to.
Thank you, Mr. Lenthal, my colleague. Bill is not my bill. We both, Senator DeFrancisco and myself,
I apologize. I meant to say that if I didn't.
That was not a complaint or indication that I thought that way. However, Senator DeFrancisco and myself, I am pretty sure, very strongly believe in the need for checks and balances on one part of our government and our criminal justice system, our legal justice system, where the holder of the office is endued, authorized with tremendous power that has immeasurable impact on the lives of anyone who has the unfortunate opportunity or cause to appear before the justice system seeking justice. In every other part of the government, the presidency has significant checks and balance. Our judges, even themselves, has checks and balances. There exists for judges who have tremendous power a commission on judicial conduct, and so. But prosecutors who have a unique power to make final decisions in cases before the case even go to the judge, can determine, and in the community that I represent, a lot of where thousands and thousands of African American youngsters appear before judges making plea deals, many offered without a prima facie case having been even proved to exist. It's just an example of the power of the prosecutor. So we have put together what we think is a recommendation. We want to enact that into law that would provide a source of check and balance where anyone who has a problem, a concern that the office may have been abused or the owner of the office may have indulged in misconduct of any nature, not intended or otherwise, but certainly contrary to what we think to be a true justice approach to justice, will be able to make a complaint and have the complaint properly addressed. So we are thankful that you are joining us today, and hopefully we'll hear from you. Just finally, I'd just like to mention that we were very careful to not, or we have taken, made the effort to not have this described as a commission on misconduct, but all sorts of conduct by the prosecutor. You will complain, it doesn't necessarily have to be a complaint that is a case of misconducting themselves, but also complaints that impact on the office. Thank you.
Thank you, Nick. So just before we begin, I want to make some short remarks.
It's too late. We gave you the opportunity already.
I'll take it anyway.
Okay.
So the point of our discussion today is, well, let me say this. I began my tenure in the state legislature in the state assembly in 1973, and I have seen the power of prosecutor's office grow enormously in that period of time. And partially because of legislation that we have passed in Albany. And power is good, but we also know that power can corrupt. And so, you know, we're in the midst now of a whole host of pieces of legislation that we want to adopt in order to prevent corruption from public officials, as all of you know and have read about in the newspapers. And so it's not because we don't want to leave anybody out that we're having this hearing or discussion today. But it is important when, as Mr. Perry said, we understand that prosecutors now have, as I've suggested, an enormous amount of discretion regarding both the investigation and prosecution of crimes. And it's in the public's interest to promote acceptable standards of conduct, like we did for judges when we saw that they had tremendous power that they may have been using in an unsavory way. And so, not to suggest anything, but just to bring this topic to the forefront in an intelligent discussion. That's why we've chosen the roundtable model to do it. And I agree with Senator DeFrancisco and Assemblyman Perry that this is the kind of balance that we wanted to achieve in promoting this discussion. So let us begin.
Thank you. The bill was really modeled after the Commission on Judicial Conduct that's been in effect for many, 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 many years. So what I'd like to do is the first call on Robert Tembekshian, the Commissioner, the head of the Commission on Judicial Conduct, and just give a brief overview of what your operation is like and what the results have been in your point of view. By the way, we also have someone here in the second row, which doesn't mean anything about your capabilities. It just means there wasn't enough chairs. Stephen Downs was the past chief attorney for the same organization, and he can give some historical perspective concerning this commission. Mr. Tembekshian.
Thank you, Senator. And I'm happy to be here and talk a little bit about the structure and experience of the Judicial Conduct Commission over the past 4 decades. Before there was a Judicial Conduct Commission, the responsibility for disciplining judges in New York State was spread out among various levels of the court system. The appellate divisions each had responsibility for lower court judges. There was a special court on the judiciary which had responsibility for disciplining judges of the more senior or superior courts. But in the 25 years before the Commission's creation, the Court on the Judiciary, which was an ad hoc court, was convened only 5 times by the Chief Judge, which was the structure at the time. And there was, among the public and certainly in the legislature, a dissatisfaction with the ineffectiveness of the system that was then in place for enforcing rules of ethics and ethical conduct on the judiciary. So by virtue of a constitutional amendment, what was originally created by the legislature as a temporary commission was made permanent, and then our operating procedures were filled out in the judiciary law. And it's that statute, Article 2A of the judiciary law, on which this legislation, sponsored by Senator DeFrancisco and Assemblyman Perry, is modeled. At the outset, I must say that there was widespread consternation among the judiciary about the potential cloud that the creation of a Judicial Conduct Commission might cast over the independence of the judiciary. And it's a subject over which we have been especially sensitive in the 40 years that we have been in operation. And there are many ways, and I think that our results over those years demonstrate that not only has the Commission not undermined the independence of the judiciary, but in many significant respects, we have actually served to promote the independence of the judiciary. And let me say a little bit about how we've done that and how our procedures have enabled us to do that. We have a staff of 45 in 3 offices throughout New York State. We receive now roughly 2,000 complaints a year. And given that there are approximately 3,300 judges and justices throughout the court system, that's a significant number. But the number of public disciplines every year is in the range of 15 to 20. And the number of confidential cautionary letters, which are not discipline, but constitute suggestions and recommendations to a judge, number in the area of about 30 to 35 a year. We screen every complaint that comes in. The staff will clarify it where necessary. We will summarize it. We'll do an analysis of the provisions of law or rules that have alleged to be violated, and we'll present every one of those complaints, even the ones that are not about judges, to the entire commission, which will determine whether or not to conduct an investigation. Out of the 2,000 or so complaints that we receive a year, about 450 are the subject of an initial review and inquiry or a clarification, which does not involve communicating with the judge. We might look at a transcript, we might look at court records to try to get some sense of what the essence or gravamen of the complaint is, so that the commission can make an informed decision on whether or not to investigate. And out of those 2,000 or so complaints a year, we investigate somewhere in the range of about 150, and I think our high was about 225 one year. And out of those, as I said, only 15 to 20 are going to end up in public discipline. So in many respects, we absorb a lot of the public hostility toward the judiciary, much of which is the result of complainants who are unhappy with the results of their litigation. They lost, they don't want to accept it on the merits, so they make a complaint to us. And as we're required by statute, we explain to every complainant when we dismiss a complaint what the basis of that disposition is. So we are in a position to not only absorb a lot of the criticism that might otherwise be directed at judges, but we explain to the complaining public why it is that our system and the administration of justice requires that their complaints not result in any disciplinary action against the judge who just called it as he or she saw it. You'd be surprised at the number of times in a year we'll actually hear from complainants after they've heard from us, expressing appreciation for having taken the time, examine their inquiry, explain to them what our procedures are and why their complaint was not going to result in discipline. And they may still not be happy that they lost, but they appreciate or understand that it's not the system or the judiciary that's at fault. We've had, in 40 years, 805 public disciplines, and that includes 60 cases where we stipulated with the judge that the judge would leave the bench and never return to office again. Clearly, stipulations of resignation or removals are reserved for the most egregious conduct. Public reprimand, either a mild admonition or a more severe censure, for intermediate misconduct. 92 or so of those cases have been appealed directly to the Court of Appeals, which is, as our Constitution and our statute direct, at the option of the disciplined judge. Never in all of those years has there ever been a finding by the Court of Appeals or by the courts in Article 78 proceedings that have been brought against us by judges that the Commission improperly intruded on the discretionary, call them as they see them, function of the judiciary. There has never been a finding by any court that the Commission has impeded the independence of the judiciary by examining complaints of ethical misconduct that have been made against judges. In our early years, we were the subject of approximately 100 lawsuits brought by individual judges or judicial associations, challenging our procedures, challenging the enforceability of our subpoenas, challenging the scope of our investigations. But because our rules and procedures, which were promulgated, published, amended from time to time, sometimes at the suggestion of judicial associations and bar associations, are based on a due process model. No judge can be disciplined in New York without due process. And due process requires that the judge have an opportunity to respond to any complaint or investigation before the Commission would vote formal charges against the judge. And clearly, once formal charges are voted, the proceedings go to a referee, the rules of evidence apply, there is due process of law, and then after the hearing is over, the judge has an opportunity to make a presentation to the entire Commission. These are very sophisticated, time-tested due process procedures that ensure that we give to the judiciary the same rights and appearances of rights that they're obliged to offer to the litigating public.
Thank you. I'm going to take the liberty of just going down the road. Maybe we can have everybody in this table speak, and then maybe if you got questions later, that way we get a couple of rounds here. Phil Boyle, the senator, is here, very interested in this issue as well. Next, I'd like to call on Marvin Schechter, New York State Association of Criminal Defense Lawyers.
Good morning, and thank you, Senator, for the opportunity to represent the New York State Association of Criminal Defense Lawyers on this important issue. The association completely supports the bipartisan effort to pass this legislation. We have seen firsthand the deleterious effects of unbridled prosecutorial misconduct, unethical behavior, and in some instances, illegal activities. Perhaps the best way to understand what it is that the prosecutors are doing and have continued to do, and at this point have extended, is to understand some of the cases that have appeared before courts where decisions have already been made that unethical conduct has taken place. The initial presentation I have will give me enough time to give you all the cases, but I'll give you the thumbnail and then go into it in detail. Between 2004 and 2013, one assistant district attorney in upstate New York, Jeffrey L. Taylor, wreaked havoc upon the system. In 4 stated cases before the courts, the cases were reversed in 3, and 1, the courts did not reverse, all based on Mr. Taylor's unethical conduct, describing witnesses as liars, calling defendants sexual predators, asking illegal questions such as, do you have an arrest record? And it was much, much worse. What was interesting about the Taylor case is that by 2012, the courts began to understand who Mr. Taylor was. And 2012, in a case called People v. Huntsman, which the court did not reverse, the court stepped aside and said, although we're not reversing, we take a moment to caution Mr. Taylor, who we have repeatedly admonished not to conduct himself in this fashion. And that's exactly what they did. Did that deter Mr. Taylor? Did it deter his supervisors, his office? No, he continued to practice law, and in fact, he continues to work in the DA's office in upstate New York. Astoundingly, if the appellate division finds that they have to admonish an attorney repeatedly, one would have thought that the disciplinary system would have kicked in. And to that end, the New York State Association of Criminal Defense Lawyers made a complaint. Rare for the association, which has a structure for doing that, and which I think has rarely been used along the lines of what Mr. Tembekian was just talking about. 2 letters were sent to the Grievance Committee of the 7th Judicial District. Both letters were rebuffed. The complaint filed by the association was not even considered. And that should underscore for the 4 of you how dead, how moribund the disciplinary system has become. Today, one of the things that we should explore, and I hope we'll get some questions on this, is how the lack of accountability has totally contributed to this excessive misuse of power. There were 2 structures for accountability of prosecutors.
Mr.
One,
Schechter, can I interrupt you for
Sure.
just a second? I think it's necessary, I guess, for some of us who may not be aware of it, including me, as to what the disciplinary proceeding for a district attorney is and how that differs from what was available to a judge prior to the Commission on Judicial Conduct. And is the procedure, as I think it is in my mind, the same kind of disciplinary proceedings that's involved for any defense attorney that we're talking about for a district attorney?
would you like me to go into it now?
Yes, please.
As we understand the disciplinary procedure from what we've been able to learn, because a lot of it is shrouded in secrecy, a complaint is made by a bar association, by an attorney. In fact, it can be made by any member of the bar, including non-members of the bar. The public can make a complaint. The complaint goes into the disciplinary committee. It is then evaluated for its efficacy and veracity. Now, initially, a lot of these complaints never get past that stage. So we don't know, because there's nothing published that indicates what happens and how that procedure works, that initial screening process, if you will. But assuming it gets past that stage, it goes within the disciplinary committee to members of the disciplinary committee. And here lies the rub. In some of the disciplinary committees, in some of the departments, the complaint goes to panels of 2 or 3 members of the disciplinary committee. But in others, the complaint, particularly when it involves a district attorney, is shunted aside. Let me give you an example of that. In Manhattan, in the first department, the disciplinary complaint goes to an executive committee, culled out from the total membership of the disciplinary committee. That committee then decides unto itself whether or not the complaint has any validity. If it gets that far, and it gets into that kind of analysis, the district attorney is permitted to respond to the complaint, and in fact, the district attorney comes in often to plead their case. Line district attorneys are often accompanied by executive assistants, and these are not just normal supervisors, they're usually much higher supervisors, usually people very close to the district attorney. That was the case, for example, for many years in the Bronx, where one of the executive assistants, one of the top authorities, was the liaison from the district attorney's office to the disciplinary committee. And that person then explains to the disciplinary committee what the complaint is. Many members of the disciplinary committee are not criminal defense lawyers. They are not former prosecutors. Large numbers of them are civil people. These disciplinary committees are the result of appointments by the judiciary. Now, when the district attorney goes in and pleads their case, the complainant, the person who made the complaint, for example, myself, is not informed of anything going on in the committee. In fact, not only are you not informed, but whatever the final result is of that procedure in closed door session is never reported out to the complainant. And for years and years and years, and this is my 43rd year in the practice of law, we have no idea how these complaints are being processed. But rather than continue it, if you want to see how bad the system has become with respect to disciplinary committees, you should read an article in the Fordham Law Review that was published by a defense attorney named Joel Rudin. It is dated November 2011, and if you wish, Assemblyman Lentol and Senator DeFrancisco, the association will make it available to you under separate cover. This is an extraordinary article because it explores the very issue that you just talked about. So that's how that works. So without taking up more time of my fellow panelists before you, I will go into other cases, 2 of which I brought to you today, which have never been reported publicly, including one that has recently happened in which a district attorney's office sought to isolate a defense attorney who made a legitimate motion on behalf of her client by exacting economic retribution against this individual attorney. Case is still pending. We're waiting to hear what happens, but it's an extraordinary misuse of the prosecutorial power outside the courtroom. I want to bring to your attention 2 other cases today out of the Bronx. Remember, as we sit here today, that the National Registration of Exonerations...
Excuse me a minute.
Yes.
I really appreciate the detail that you're giving. We got 12 people in
I'll
questions.
finish up.
So you got to, as far as the cases, if you summarize them quickly, so everybody gets the opportunity.
I'll be happy to sum them up as follows. Some of the worst cases that we've seen in the last several years are out of the Bronx. The Bronx, as you know, from the National Registration of Exonerations, is either the 4th or 5th worst county in the United States of America for wrongful conviction. This has been going on in the Bronx way back into the 80s. Mr. Rudin, in his Fordham Law Review article, traces the history of prosecutorial misconduct in that borough in detail. Thank you very much.